inventor and mathematician who said, Isaac Newton, who said, if I see further than others, it's because I stand on the shoulders of giants. And that's the purpose of this webinar. We've brought together giants in the industry, in the aviation industry, seasoned practitioners, so that we can all stand on their shoulders and learn from their combined experience of over 20 years, for them to be able to translate and impact us with their knowledge and expertise in this industry, so that legal practitioners that are not practicing in this industry can actually stand on their shoulders and be able to see further than others. So that at the end of the day, hopefully, we will be able to say that we've actually learned a lot today and able to translate this to wealth. So there's not only litigation, but people can actually see that there are other areas of practice in law whereby people can make money. So without further ado, I would like to introduce the lead speaker to moderator, my learned brother Silk, Mr. Lawrence Fubura Anga, Senior Advocate of Nigeria. I'd like to read his profile. Mr. Lawrence Fubura Anga is one of the founding partners of the Alex Farm and the head of the firm's Aviation, Maritime, and Financial Services Practice Group. He is qualified to practice law in Nigeria, Ghana, and England and Wales. He has a strong multidisciplinary background in law, economics, management, and fiscal policy. He appears as counsel before all superior courts in Nigeria and has acted as counsel of party-appointed arbitrator in several arbitration proceedings. Mr. Anga has attended and facilitated several aviation-related courses and seminars around the world. These include the annual and the ABA Aerospace Law Forum. He is a member of the Forum on Air and Space Law of the American Bar Association and the Aeronautical Committee in the SBL of the International Bar Association. He was an honorary delegate for Nigeria at the 5th ICAO World Air Transport Conference held in Montreal, and at the 35th General Assembly of ICAO held in Montreal. Mr. Fubura is the founder and president of Nigeria Aviation Law Society and pioneer chairman, Aviation Section, SBL of the Nigerian Bar Association. He authored the Nigerian chapter of the Aircraft Repossession and Enforcement, published by Plua Law International. Mr. Fubura was invited by the World Bank as an expert to a joint workshop in Montreal with ATAG and ICAO on maximizing civil aviation's economic impacts. He was chairman of the Legal and Regulatory Subcommittee of Nigeria's Federal Ministry of Aviation National Steering Committee on Safety, Quality Assurance, and Reforms. He advised the industry and the national regulator, the Nigerian Civil Aviation Authority, on the Nigerian Civil Aviation Act. Mr. Anga was appointed by the Nigerian Civil Aviation Authority as a member of a legal review committee for the revision of the draft Nigerian Civil Aviation Economic Regulations, and is also a member of the appeal panel of safety violations set up under the Nigerian Civil Aviation Regulation. He has facilitated NCAA-sponsored training for judges in aviation. He was appointed a member of Nigerian Contact Group of AWG Committee on Implementation of the Cape Town Convention. Mr. Fugura is listed in the International Directory of Uzu in Aviation Law and was the only Nigerian solicitor for over 10 years. WWL says Lawrence Fugura Anga-san has extensive aviation sector experience and receives praise for his solutions-oriented advice. Mr. Fugura is a senior advocate of Nigeria, the light of Numba, and he holds the traditional title of Olu Soku, and also
those commit themselves to work will be very few. If you ask me,
can you mute that speaker? Audrey, can you mute that speaker?
Yes.
All right. The qualifications of Mr. Anga is a BA. He holds a BA in Economics and Political Science in Yale University, United States of America. He also holds a BA Law in Churchill College, Cambridge University. He also holds a MA Law in Cambridge University, England. He is qualified to practice in Nigeria as a barrister and solicitor. He is qualified to practice in England and Wales as a barrister. And is also a barrister and solicitor in Ghana. His areas of practice include aviation, banking and finance, project finance, capital markets, maritime, infrastructure, and corporate finance. Without much ado, I'll pass it on to Mr. Anga to moderate this event and to introduce the other speakers. Mr.
Leonard Silk. Okay, yes. Sorry, Leonard Silk. Apologies for interjecting, but Madam Chair has now joined us, please.
Oh, okay.
If we can allow her make her remarks before Mr. Anga takes over. Apologies for that, sir.
All right. Good afternoon, Dr.
Hawa, I'm sure you're trying to. Thank you very much,
our chairman. Chairman, thank you for joining us. I'll just allow you to make your opening remarks, madam.
Very much, my Leonard Silk. Distinguished senior advocates of Nigeria here present, our eminent speakers, panelists for today's event, the leadership of the Nigerian Bar Association Abuja branch section on legal practice. I am very, very elated. I'm so happy to be here to join on this, I would call it very important webinar that seeks to expand the scope of legal practice of our members. I want to really, really express my gratitude to the distinguished and eminent speakers that are online to provide with to share their experience, their knowledge that would help some of our members understand how to expand the scope of their legal practice into the aviation sector. This is not that only out of conviction that when you share knowledge, you make the world better. I really want to thank them to imagine that none of them is being paid a dime. None of them is being given a kobo for coming to share their knowledge, to share their experience, and also eminence schedules. Yet you turn of your time in order to carry out this capacity building. The branch appreciates you. We thank you so much. And it is our prayer that will reward you abundantly. I want to appreciate the committee that organized this, the section on legal practice. I want to thank you all for dedicating a lot of your time into planning for this webinar. I thank you all so much. The chair, Ogechi Abu, and the alternate chair, my learned Sikh Tunde Babalola, Senior Advocate of Nigeria. We thank you so very much for all your effort, for all your hard work. I also want to thank members for also finding this very worthy. I'm so impressed with the number of participants that we have. I believe that you will never regret spending time to attend this webinar. I wish us all a very, very fruitful deliberation and a very successful webinar. Thank you very much.
Thank you, Madam Chair. Thank you for finding time out of your busy schedule to join us. Without much ado, I'll now pass it over to Lana Silk, the lead speaker and the moderator of this event, Mr. Lawrence Fubura Angasan. Thank you very much.
Good afternoon, distinguished ladies and gentlemen. I salute all my learned friends in the Silk present and all the other very senior members of the bar and members of the Abuja. Can you hear me? Members of the Abuja.
We can hear you, sir.
Okay, good. Unity Bar.
You are breaking. You are breaking.
Okay, can you hear? Is it clearer now? Is it clearer now?
Yes, we
yes,
can hear
it
you.
is, sir.
Yes,
Oh, okay.
yes.
Okay. First of all, let me thank the Abuja branch of the SLP. Its chairperson, Dr. Hawa Shekarau, the SLP committee chair and alternate chair, that is Ms. Ogechi Abu and Leonard Silk, Mr. Tunde Babalola SN, for inviting me to moderate this webinar. It's something, aviation law is something that's very, very close to my heart, and I'm very grateful for the opportunity. We are very fortunate today to have a very distinguished and a stellar cast of speakers who are going to share their knowledge with us. There are people who have vast experience in aviation law, and not just aviation law, but over other areas of law as well. The theme is an interesting one. It says, how do you develop a lucrative aviation practice? And I ask myself, is it a question of a lucrative aviation practice? Is being lucrative synonymous with being successful? Does it mean how do you develop a high quality, predictable, efficient, cost-effective legal practice that gives your clients the best representation possible? Because in many ways, before you talk of it being lucrative for the lawyers, first and foremost, it has to be lucrative for the clients. And I think by the time we finish this webinar today, at least in the area of aviation law, many of us would learn not everything, a thing or two. Now, aviation law is a very fascinating subject. It's as wide as the sky itself. You've heard the saying that if you build a 3-kilometer road, you end up 3 kilometers from where you started. But if you build a 3-kilometer runway, you can actually get to any part of the world in a matter of hours. And that really is what aviation is all about. And so when you talk about how do you build a successful aviation practice, I think what comes to mind is representation of airlines or maybe passengers and all that. But it is such a wide area. and its scope covers almost every single aspect of law that we practice. And so I think the message really is that open up your minds and you discover that aviation law touches upon every other aspect of law, just as the economic impact of aviation touches upon every aspect of an economy. Now, arguably, the aviation industry is probably the most regulated business in the world. And so, from the point of view of a lawyer, aviation is a veritable gold mine, because you start from international treaties and air instruments. You talk of domestic laws, domestic regulations, domestic policy. You have to deal with contracts. You have to deal with infrastructural development. You have to deal with financing of aviation equipment. You're going to talk about labor issues. You talk about international migration and immigration. You talk about things like public privatization and concessioning of national aeronautical and aviation infrastructure. You talk about safety issues. You talk about security issues. You talk about air navigation services. You talk about regional and international trade, open skies. You talk about trade liberalization. In aviation today, as far as it concerns Africa and Nigeria, you have of course, the AFCTA, but you have before then the 1988 Yamoussoukro Declaration, which became the Yamoussoukro Decision in 1999. And only 2 years ago, you have the Single African Transport Market, the Single African Air Market. You have so many laws that provide an opportunity for lawyers to advise upon and to deal on. And today, our panel of speakers are going to give you just a little bit, just a little taste of how fascinating the subject of aviation law can be. I think one point which I would like to emphasize before we go into the substantive webinar itself is that your practice can only be as lucrative or as good as you put into it. You have to invest in it. As I've just alluded to, it's a very technical subject. And if you don't understand the technicalities, then you're wasting your time and the time of your clients. And so I think the first lesson really is that you have to sit down and invest. You have to invest in the books. You have to invest your time in developing the knowledge. You have to invest your time in making the contacts. I've been told by some juniors that, oh, there are only so many airlines. Mr. Anga, you've been representing some airlines for 30 years, 40 years. How there's no space for us? I said, no, don't say that. There's space. And the way you build your practice depends on you. But I think it's a case of taking your opportunities when they arise and grabbing them with both hands. I'll tell you a very quick story. My first aviation client, an airline, what happened? I was traveling in 1988, I was going for the IBA conference, which was being held in Buenos Aires. At that time, there was a Varig airline, which is the national airline of Brazil, that had one flight once a week. I took that flight, I flew business class, and I had only a carry-on bag. No problem between here and Rio de Janeiro. But when we got to Rio, they were going to transfer us to Buenos Aires, but the plane they brought was much, much smaller. So at the point of boarding, they took my carry-on bag. And I told them, I have no other luggage. I just have my clothes in this thing. I have nothing else. They said, no, they took the bag from me. I said, don't lose my bag. They said, well, your bag won't get lost. Of course it got lost. I'm still looking for that bag up to today. And so I flew all the way to Buenos Aires. I had very little money. I had no clothes. I attended the first 2 days wearing the same pair of jeans that I used to travel. And of course, I was understandably very upset. And with the advice of late Chief EOA Idowu SAN of Chris Ogubanjo and co then, and then later on his own practice, he gave me a few rudiments as to how to approach suing the airline. Needless to say, I gave them such a hard time that they said they would rather have me as their lawyer than have me acting for people against them. soon after, I got my first permanent airline client, and I got them through a totally different route. I did something for the man who ultimately became their general manager. Very small matter. I didn't charge him for it. I didn't know who he was, but he was so impressed by what I did for him that he said, "You should be representing our company." And the rest, they say, is history. So that's the other point I want to make. I find that a lot of lawyers these days only think of the lucrative part. They only think of the money part. And I think for the younger lawyers and for all of us, think of your client first and the money will follow. So we can discuss that a little bit more as we go along, but I'll now take the opportunity, and it's a very pleasurable one, to introduce our first of three speakers. It's a pleasure to introduce Mrs. Chinasa. I'm sorry, just a minute. Forgive me, I had her profile in front of me a minute ago. Yes, okay. Yes, it's a pleasure to introduce Mrs. Chinasa Unoagbunam. She is, as they say, a very, very experienced lawyer with professional experience in dispute resolution and in advisory matters. I've known her for very, very, very many years, and her partner and colleague, Mr. Uwaitigwe S.A.N. She has been actively involved in advising and representing major international clients in the aviation, oil and gas,
Chinelo, please unmute Mr. Anga. Did you mute him? Please unmute Mr. Anga. Oh God.
I've unmuted him, but
okay, I think she's unmuted me now. I don't know where. Let me start again. I was reading Chinasa's profile, and I was saying that Mrs. Chinasa Unoagbunam is a seasoned lawyer with vast professional experience in both dispute resolution and advisory services. She has been actively involved in advising and representing major international clients in the aviation, oil, gas, and power sectors. Her litigation and arbitration experience spans a wide range of commercial disputes in oil and gas, banking, aviation, employment, and other commercial litigation. She was part of the team responsible for drafting the Civil Aviation Act and the subsequent declarations made by Nigeria in pursuant to the Cape Town Convention. Chinasa is the firm's team lead of the aviation practice of stream sales and cone, and she has been involved in the recent review of the proposed amendments to the aviation legislation in Nigeria. I believe there are about 6 bills on aviation before the National Assembly, and she and her team have been very much involved in that. In addition to being a fellow of the Chartered Institute of Arbitrators, UK, Chinasa is also a member of the International Aviation Women's Association. She is also a council member of the NBA section on business law. And I can tell you for free that she is one person who has invested a lot of time and energy and her talent to the development of aviation. And it gives me great pleasure to invite her. It gives me great pleasure to invite her to speak on introduction to passenger rights, carriers liability, and related issues. Mrs. Chinasa, please, the floor is yours.
Thank you, Leonard, and thank you very much as well for that introduction. Not just my profile, but your introduction about the sector in general and your advice as to how we should all look at developing the practice in our individual capacities. I also say thank you to the NBA Unity Bar for inviting me. I don't take it for granted, and I hope that we're able to share the little knowledge we have and give your audience something to go home and is there. I think I sent my slides. I don't know if they're able to share my slides. I'll be speaking on, yes, I think Mr. Anga has actually dealt on the topic, and I agree in total about his views on that topic, developing the lucrative aviation practice. I totally agree with what his views on that area. So the topic I'll be speaking to, introduction to passenger rights, carrier liability, and related issues. Next slide, please. So can we go to the next slide, please? So the context will involve looking at the laws and the conventions related to passenger rights, contracts of carriage, passenger carriage, as well as baggage and cargo. Then we'll look at carrier's liability, which is essentially, when litigation lawyers talk about litigation in aviation, they're looking at liability for death, body injury, and liability for loss of baggage or destruction of baggage or delay. Those are the major core issues that most lawyers in litigation concentrate on. Then we're looking at the limits of liability and breaking the liability limits included in those laws and the conventions. Then I'll talk a bit about jurisdiction of our courts, in the sense that, of course, we have the state high courts and then we have the federal high courts. A decision has come up that makes it a bit confusing about where you can go to litigate your claim in Nigeria. Then I'll do a brief summary of the NCAA consumer protection regulation in terms of denied boarding, delay, as well as cancellation. Next slide, please. Can I have the next slide, please? Oh. Okay, yes. I'll start with the Warsaw regime. Ideally, we should start with our own Civil Aviation Act. Civil Aviation Act is the act that sets out what the aviation industry in Nigeria looks like. The laws, regulations in terms of passenger, in terms of contracts, most of the things you're going to do is set out in the Civil Aviation Act, including the power of the NCAA to make the regulations that deal with some of the issues that Mr. Anga raised: security, aircraft maintenance organizations, getting your air transport license, all those things that deal with establishing or undertaking an aviation business is sort of compressed in the Civil Aviation Act. But over that, in terms of liability, carriage of passengers, you have the Warsaw International Conventions. And the first convention, of course, was the Warsaw Convention in 1929. That is the first attempt at unifying rules that will regulate passenger rights when they're being carried by air. And over the years, there were amendments to that convention, several amendments, particularly with respect to the liability limits. And of course, certain other issues that over time, it appeared that the Warsaw regime wasn't now dealing with the real core issues in terms of, the liability that arises from carriage by air. The next slide, please. Subsequent to the Warsaw regime, sometime in 1999, state parties also gathered together and revamped the convention relating to carriage by air. And that gave us the Montreal Convention. The Montreal Convention was signed in 1999, but it entered into force on 4th of November 2003. And for Nigeria, because of our constitutional requirements, we have to, of course, by constitutional right, incorporate it into our laws. And that was done by the Civil Aviation Act that was passed in 2006. If you go to section 48 of that Civil Aviation Act, we see the incorporation of the Montreal Convention into our local law. Now, there are two aspects of that convention. You have the part that will apply to international carriage. That is in section 48.1. And then you have a modified version of the convention, which will apply to local carriage. There are some distinctions in terms of course, monetary limits, probably time to change the limits that have been set in the convention, but there are two separate conventions in the Civil Aviation Act, the one that will apply to international carriage and the one that will apply to domestic carriage. Now, we need to understand that down the slide, you see also where it's explained that for international carriage, that means that any carriage between Nigeria and another state party who is also signatory to the Montreal Convention, the terms of the Montreal Convention will be the applicable law that will govern their rights and obligations in case of any of the issues that have been covered under the convention. Next slide, please. Can I have the next slide, please? If I may, I can also look through my own slides and assist. Okay, thank you. There's a little error on that. So the next slide talks about the objectives of both conventions, right? And it's a laudable objective to develop clear rules, unify the clear rules that will govern the rights and obligations of carriers and passengers in international carriage. And it just makes sense, because if there's anything that occurs in a contract of carriage, you don't want people, debating first of all which rules are going to apply, which place is going to have jurisdiction, what are the kind of damages that will be awarded depending on the jurisdiction. Of course, if it's an American court, for instance, looking at your accident claim, you're looking at millions and millions of dollars. So it just made sense that, there was some unification of the rules that will apply if there's anything, any accident or anything that arises from a contract of carriage. So those were the laudable objectives from the Warsaw and the Montreal Convention. Now, I'm sure you're hearing me mention Warsaw, and then Montreal. Because of the length of time, Warsaw applied, even though there were modifications, it just makes sense that we should still consider what it did for, liability for passenger carriage by air, because the definitions, how courts interpreted certain terms that were included in the Warsaw, which are also terms that are in the Montreal, the regime created by the Warsaw will still be relevant, even when we are now applying Montreal, and that certain terms are different. It's also important to note that for some countries, if for instance, like Nigeria now, I remember when we did the Civil Aviation Act, we repealed the carriage by air order that extended the Warsaw to Nigeria. I know a lot of people quarreled about that, because they said, look, if you only have Montreal and there's a carriage between two state parties and one is not signatory to Montreal and only signatory to Warsaw, you have you are left with a situation where now what laws are going to apply. You are now still facing that situation of not knowing the precise law that will govern liability. But what we have is Montreal, because we feel, or the people that gathered and drafted Civil Aviation Act felt that it was better to have a more modern convention governing carried by air for Nigeria than still retaining Warsaw. Next slide, please. So next slide talks about the applicability. I think I've mentioned that it applies between state parties, right, who have either signed or acceded or ratified the convention, right? And again, even if the destination is also important, is very important, it will apply if the flight is taken off from A and going to B, two state parties who are signatory to Montreal. It will also apply if state A is signatory, is an international carriage. It takes off from, for instance, Nigeria, stops at a particular place who is not a party to Montreal, but returns to Nigeria. Montreal, the Montreal terms of the Montreal Convention will still apply. So, you know, for international carriage, for local carriage, and all over the country, all the local airlines will be applying the modified version of the Montreal Convention as stipulated in the Civil Aviation Act. Next slide, please. Can I have the next slide, please? So we talk about contracts of carriage. This part is, you know, we're all used to buying our tickets and, you know, sending something by air and we issue a ticket or a way bill covering our baggage. So those tickets symbolize our contract between us and the carrier, right? And it will indicate where we're taking off from, indicate where we're going. It will give us the terms and conditions of our carriage. Now, many times, the entire terms are not, you know, the paper you simply print out from your laptop will not contain the entire terms and conditions that will govern the carriage, but it is mandatory. The terms of the Montreal must always be stipulated, even if it's not in the terms of the contract. You have that part of your ticket that will say, you will know that this contract, there are terms and conditions that govern this contract. And when you go to those terms and conditions, even though they are online, you always see, it is always there that the terms of the Montreal Convention govern the carriage and that your liability of the airline is limited by that Montreal Convention. The airline cannot, not include that term. It is always a term of the contract of carriage between the passengers and the carrier, both for passenger tickets, both for your baggage, both for your cargo. And the ticket, the contract will stipulate most of the terms already set out in the convention. But because nobody wants you to be handling a bulky document, you have your simple slip of contract, and then the entire terms and conditions will be stipulated online, of course, with the advent of the internet. When it was under Warsaw, contracts of carriage used to be technical. You need to deliver the contract of carriage to the passenger and ensure that the passenger understands, what that contract of carriage entails. But under Montreal made it a bit easier, made it possible for electronic ticketing, and it's still there that the liability of the airline is limited based on the Montreal Convention. Next slide, please. Can I go to the next slide? Because the airway bill and the cargo receipt all form part of the contract of carriage for all the several aspects of carriage: passenger, baggage, cargo. So this is the major areas covered under the Montreal Convention. Now, the carrier liability for death, bodily injury, delay, loss, or destruction or damage to cargo baggage. Now, the Montreal Convention, now under Warsaw, the wording of the liability was a bit different, right? But the Montreal Convention, but you still had words like accident, you still had words like death or bodily injury, you still had words of operations of embarking and disembarking. So Article 17.1 of the Montreal Convention is the first article that deals with the liability of the airline. Now, what it says is that the carrier is liable for damages sustained and the death or bodily injury of the passenger upon condition only that the accident which caused damage or injury took place on board the aircraft or in the course of any of the operations of embarking or disembarking. Now, it looks like a simple provision, but it had the language of this provision has been subject to a lot of judicial interpretation. Now, issues such as what is an accident, what is bodily injury, can other injuries that Somebody is raising his hand. I don't know what the issue is. Can you please hear me?
Chidasa, we can hear you. Continue, please.
Okay. So the issue like what is an accident? You know, what death is fairly clear. If someone is dead, the person is dead. What will the court interpret as bodily injury? When is it that there's a cause of the operations of embarking or disembarking from an aircraft? So these are all terms that have been subject to several judicial interpretation. There's an American case, Air France and SACS, that has defined accident to be something that was completely unexpected by the parties. So it has to be something that you did not foresee. And then bodily injury has been defined as something that has actually injured you, incapacitated you. So if you're bringing a claim for like mental injury, or if you're bringing a claim for pain and suffering, if you're bringing a claim that, you know, does not
Administrator, please, I think you muted her microphone.
I can't even see the camera on I can't see.
We can see you and we can now hear you.
Oh, okay, I can't see anything on the screen, so I don't know. I'll probably just go on using my own slides. So what I was saying is that the interpretation of what constitutes an accident and has, you know, what then is bodily injury. So when you're bringing a claim for like a mental injury, pain and suffering and all that, many of the courts have said that do not fall within the confines of the convention. So it's advisable that if you have a claim or somebody brings a case for you and say, I want to sue an airline and this is what I think I went through. If, of course, you look at the convention, you look at the claim and you look at the facts that the person has brought you, you then have to consider on the word head of claim, if it's 17.1, can this be brought? Was the person injured? And injury can be in so many ways. There's an American case as well, where somebody ordered a gluten-free lunch and the airline made a mistake and gave her something that gave her severe allergies. So unfortunately for her, she brought a claim on the common law. And the court held that, look, the convention is the only basis for you to bring a claim. If you can go back, come and bring a claim under the convention and we'll look at it, because any other claim you're bringing out for under common law will not apply. So I'll still talk about some of the other cases in relation to how Article 17.1 applies to cases. Now, 17.2 is in relation to baggage. If your bag is destroyed, if it's lost, if it's damaged, and all those kind of things, you can still sue the airline and, you know, claim damages in line with what the provisions of the convention has made. Now, I know that further down, I'll talk about the limits of liability provided in the convention, because that will give you an idea of why, in most cases, when you bring a claim, you know, the airline can put up a defense and say, no, I'm not liable to pay you this much because the convention limits my liability to this much. Now, I'll also talk about when you can go further to say, well, I understand the convention limits your liability to this much, but for this circumstance, I am saying that you should be able to pay much more than the limit set in the convention because you did A, B, C, or X, Y, Z. Now, so for damage, the liability also creates, the convention also creates liability on the airline if your bag is lost or is damaged or it is destroyed. That is provided for under 17.2. Then you also have damage to cargo. and as well as delay. So for these heads of claim, what the convention has done is to limit the liability of the airline, to say, for if these things occur, you are not expected to say, no, I am not liable. But again, I'll stress that not being able to say you're not liable doesn't mean that the passenger is automatically gets the limit that has been set in the convention. What it essentially says is, to the extent you're able to show that that is the loss or the damage that happened to you by virtue of what happened, the airline is not expected to say, no, I'm not liable to that extent. So that's what the limit of liability in the convention actually stipulates. Now, we go to I'll talk now a bit about the liability limits. Now, for international carriage, the liability limits are also set inside the convention, and they range for deaths. Now it's about 120-something thousand special drawing rights. A lot of us can check on the internet what special drawing rights are. Special drawing rights are essentially, a bucket of currencies from different countries. You have the euro, you have the pound sterling, you have the Chinese yuan, and you have the US dollar. So at each particular time, once the liability is established, that is what the monetary units that will be used to determine what is payable to the passenger. But for domestic carriage, our denomination will use the US dollar to peg our own limit. So if you go to the second schedule or the third schedule in the Civil Aviation Act, you will see that for debt to passenger, the liability limit for the carrier is about 100,000 US dollars. We're expected to review those limits every 7 years. I'm not quite sure if the limits set by the 2006 Civil Aviation Act has actually ever been reviewed. Now, you also have limits for loss of baggage or damage to baggage. It's about 1,000 something for each passenger. For delay, it's about the current limit is about 5,000 something for each passenger as well. And then for damage or loss or destruction of cargo is measured in kilograms. So I think it's about 19 SDR per kilogram. So the convention already has set those limits. And I forgot to add that for international carriage, there are also review of the limits every 5 years. There's a way the convention allows them to review the limits every 5 years. So it takes care of the inflation that will go on as the years go by. So now let's now talk about how the courts have interpreted what the claims that you can bring under the convention. I find the cases under Nigerian law has been, for me, a bit, I wouldn't say that we have totally not embraced the convention. We've recognized the convention right from when it was Warsaw, the cases of Lufthansa and that actually recognized the application of the Warsaw Convention that was extended carried by air order, and subsequent decisions as well. But the question is, how have we then, interpreted whether it is a claim has fallen squarely within the convention or has fallen out of it and should not, should maybe form the basis of a separate kind of claim and not a claim under the convention. And these distinctions are very important because we want to be able to show that we are aligning with the objectives of the convention, in terms that if the claim fairly falls falls under the convention, that you brought it under the convention. Is it a claim for delay? Is it a claim for bodily injury? Is it a claim for loss of baggage? You know, so that it is clear, very, very clear. If we look at the cases, I mean, there's a very good one, British Airways and Atoebi. I'm sure most of us have seen that case, you know, right from the court of first instance. Although the respondent did not, you know, set out the case as if it was a case of delay. And if we look at the particulars of the claim that he made, you know, he made claims for, I went back, I bought a business class ticket, I had to fly back, I had to bring my bag back, and, you know, I had told these people to give it to my my assistant in London, they refused. So the airline was arguing that, look, this claim falls outside the convention. Although in the Supreme Court, the Airlines Council admittedly agreed that, okay, it can be a claim for delay. But their argument was that, look, Mr. Atoebi did not, you know, establish a case of willful misconduct. I'm going to come to that. That's the plea of a passenger where he or she wants to say, I want to get more than the limits that have been set in the convention. What then do I do to get more than the limits that have been set in the convention? And one of the ways of doing that is by saying, airline, you have been guilty of willful misconduct. And that willful misconduct has been interpreted to mean, you know, not just gross negligence or crass negligence or, you know, or recklessness like we see in our normal cases for negligence, but it has been defined as, you know, a misconduct, a negligence to which the will is a party. You know, you mentally or you knowingly do something to cause that damage. And if the evidence that has been provided to the court shows that, look, you knowingly did something to cause the damage, then the court will find that, look, you are guilty of willful misconduct. But interestingly, willful misconduct is a term that was included in the Warsaw Convention. We note that that term wasn't included in the Montreal Convention, but because, again, the ways that the Warsaw has been interpreted to involve cases where you have to show really that the airline deliberately did something to cause that damage, certainly you'll be able to get more than the limit set in the convention. So in the case of British Airways and Atoebi, Mr. Atoebi was able to show that, look, everything I could do, but you definitely, British Airways, you refused to give me my bag. I came to the airport and I told you I had important things in the bag. I had to fly back, and he particularized his claim. And the court held up to the Supreme Court. The Supreme Court held that the airline was guilty of willful misconduct. Now, there are also several cases where we can look at to show how the courts have interpreted, you know, when we can rely on the convention, as well as when the court will hold that, look, the limits, because many times when passengers sue, we are not suing because they don't know that, okay, the airline's liability is limited and that they can get such and such amount. They want to get more, and they feel that they can get more. For instance, if it's a delay, the limits in the convention is quite low. It's now $5,000, just a little over $5,000. Anybody who will, of course, is on a business trip and gets delayed in such a manner that you lose an opportunity, you won't want to get just $5,000. You want to be able to show that you're entitled to more. So many times when passengers are suing, they're looking to break the liability limits that have been set in the convention, and they want to gather every shred of evidence that they use to ensure that they are able to break that liability limit. So there are several cases that have been decided by courts to show that, you know, you can break those liability limits. Haka and Air Services, there's Cameroon Airlines and Ochichuzu. Now, I'll advise that when we are reading these cases, we should, you know, look at tenuous distinctions so that we're able to know, yes, this is when we should bring our claim under the convention. I say this advisedly because I've seen some decisions where, for instance, cases are, somewhat brought under the convention, but when you look at it, it does appear as if it may not be a convention claim. That is, it wasn't an accident, or it wasn't a bodily injury, or it did not occur in the course of contract of credit, or when the passenger is embarking or has embarked in the aircraft. So, because you may get to a court who is fairly versed with what the convention provisions are, and that you don't want to be caught, out of your guard and saying, okay, look, this is not a convention thing. I read an interesting case, the case of McQueen and Emirates Airlines, I think. And that case for me, it involved denied boarding. Yes, denied boarding, I won't classify denied boarding as a convention claim because the passenger hasn't boarded. And if he hasn't been given a passenger, if he hasn't been given a boarding pass and allowed into the aircraft, I would think that case will fall squarely outside the convention. So I've talked about I'll mention an important point. I think I've scattered around it a bit, but it's also important to note it. Article 29 of the convention deals with the basis of claims under the convention. I think this comprises most of what I've spoken about already this afternoon. And the wordings of that article is very interesting. It says, in the carriage of passengers, baggage, and cargo, any action for damages, however founded, whether under this convention or in contract or tort or otherwise. Many people have interpreted this short sentence as saying, there's no other way. If your claim does not come under the convention, you can't sue at all. I think that's not the correct interpretation to it. But, there are several cases for and against the issue of saying this convention provides the sole remedy for a passenger under a contract of carriage, or that you can also bring, of course, several claims. And I have mentioned claims bordering mental anguish. Some people go through a lot if they have an issue arising under a contract of carriage. For instance, in the case of Sidhu and British Airways, it happened when passengers flew into a particular aircraft. I think it was during the invasion of Kuwait by Iraq, and they got stuck. They were there for 9 days. So it occurred during the contract of carriage, but they brought a claim for, mental anguish and all kinds of things. And the court said, look, it's not a convention claim. You're not showing me bodily injury and that kind of stuff. So I think, if a contract of carriage, you have those kind of cases, one has to know how do you then bring claims covering those kind of damages, because certainly people must have gone through anguish, mental torture, not knowing what's going to happen to them in that kind of situation.
You're muted, Ma.
Chidas, I don't know if you can hear us. I believe your microphone is muted.
Can you hear me now? Can you hear me now?
Yes, we can. Thank you. Thank you.
Yes. Okay,
you were talking about exclusivity of claims under Article 29.
Yes, okay. I was. So I was saying, the jury is out there. as to, but many of the cases have, upheld the fact that the convention claims are exclusive. If it's not a bodily injury, if it's not something that falls squarely within the convention, that then you cannot rely on the terms of the convention. Now, what are the effects? Again, the airline of course, first of all, the airline relies on the limits of the convention to say that, look, my liability is limited and I'm not expected to pay you past this amount unless you can show me that I was negligent. But under the Montreal, I think the onus is actually on the airline now to say that, look, I've done everything I could and I wasn't liable to the damage that occurred. And again, the airline can wholly or partly exonerate itself if the damage that occurred occurred because of something the passenger did or somebody claiming through him. So these are all things that if you're bringing a claim, you should actually look to check and see that, okay, how strong is my claim in this regard with the facts and circumstances that I have before me. Next slide, please. Okay, I've spoken about, I think I've already spoken about breaking the liability limits. If you want to break the liability limits, you have to show that the airline is guilty of willful misconduct. Again, I'll repeat, the term willful misconduct is not stated in the Montreal Convention. The Montreal Convention uses a different language of negligence or gross negligence. There's a different language that the Montreal Convention uses. But I think, and I'm yet to see a case in Nigerian courts that will interpret that negligence as something below the cases that have interpreted willful misconduct. I think that the threshold will still be the threshold that was used for the for the Warsaw Convention in interpreting what willful misconduct entails. Okay, breaking in Haka is a case that happened in Nigeria as well. An airline took off when everybody was still waiting. The weather was bad. It took off, and they crash landed at the place of destination. And the respondent brought a claim over and above what the convention provided, and the court, of course, held that look, you are guilty of willful misconduct. You left when everybody else waited, and you knew that the weather was bad. So these are, when the court looks at the circumstances of each particular case, the court will be able to say that, look, I will allow a claimant to claim more than what the convention has provided for. Next slide, please. Okay, there are several other cases that we can look through in our own law reports, I think, so that I don't belabor the issue as well. I've spoken about British Airways and Atoebi. I've also spoken about Cameroon Airlines and Otutuzu. I think when we're reading these cases again, we look at how the courts have looked at the convention, the particulars of the claims that the respondent, the claimant brings in such instances. And we also have to remember that the airline has defenses. So it's not just, you bring a claim, you have to also consider, especially with baggage. I see people, once their baggage is lost, they kind of think that, oh, that's it, I go and sue the airline. You have to look at the convention and be sure that the airline does not have the appropriate defense for your claim. I once in a case, somebody consigned pirated compact disc to an African country. And when the cargo got there, the police in that country seized it, and he sued the airline and was seeking damages. I would say, look, the acts of a third party, particularly a security agency in another country, provides the airline with adequate defense. So we also have to look at what the convention provides and see, is the airline able to rely on any defense? Am I sure that this claim can be successful if I file it in court? Next slide, please. So I've spoken about the unit of measurement, which is the special drawing rights. Of course, is an IMF unit of measurement, and it changes. But for us, for the the application of the domestic part of it, we don't use SDR. It's just set out there plain is in US dollars. Now, okay, I've spoken about the exclusivity of the convention. That is a very, very important point for us. Anybody that is bringing a claim, please look at the claim. Is it a convention claim? If you're suing for mental injury, you can't bring it under the convention. You know, it's you simply cannot. You have to look for a different way of bringing it. And I also like to mention, though, I mean, I know it's not within the scope of the paper, but for instance, if there's a crash and there are victims on ground, their claims are not covered under the convention. That is the subject of a separate, convention and a separate liability regime entirely. So let's not also think that claims arising from, for instance, damage or death or injury to persons on the ground are covered under the convention. No, they are not. Next slide, please. So I put the jurisdiction question up because I came across this interesting case, KLM Royal Dutch Airlines, and because for us, the Constitution has a separate jurisdiction for the state high courts and the federal high courts. Now, in section 251 of the federal high court, there's the provision there that aviation and security of aviation and security, I think, is covered under the section 251, right? So aviation, if you ask me to interpret, is all encompassing. It's all encompassing. I don't think I can take, I don't think there should be any other definition that should come from aviation. It will mean everything that occurs in that sector. But in this case, a claim was brought for, and the respondent here got to the airport, and before he got there, they started shouting at him, your passport is fake, you are not a proper person, embarrassed him, they didn't allow him to fly, they collected his passport. So he eventually sued the airline, right? And he sued for defamation, he sued again. This is not a conventional claim, but I'm bringing it out here for our audience so that you can see that there's this case out there, so that anytime you come across a matter that you might well advise yourself how you're going, which court you're going to go to. Ideally, I think it should be the federal high court, but because of this case, you can be saying somebody telling you, well, it's the state high court that has jurisdiction to deal with this particular matter. So it's just a and held that the federal high court didn't have jurisdiction, and that was a decision of the Court of Appeal in Kaduna. Now, I've also been asked to
I'm sorry to interrupt you, but we are looking at time. I know your topic has been the broadest, but if you could just start rounding up, I'll be grateful. Thank you.
Okay, I will. Yeah, okay. So, well, I'll do for consumer protection regulation is out there. SCA has a wide range of regulation, but the part that deals with consumer protection is part 19, and it deals with issues like delay, denied boarding, cancellation, and overbooking. There are so many things that part 19 of the Nigerian Civil Aviation Regulation deal with. So we can go up, look it up and study it and see the rights it gives passengers. For instance, there's a right for refreshment, right for transportation if your flight is cancelled, and those kind of issues. So many times people don't know that those rights exist. They do exist, particularly in Nigeria. I know that many passengers don't take advantage of it, and maybe because we are all, we just want to get to where we want to go, but those regulations are there. And sometimes the airlines adhere to them, sometimes they don't. But if I share my presentation, I think you'll see the scope of what that Part 19 actually covers. Thank you very much. I hope I've been able to share a bit of insight into what the convention in relation to passenger rights entails. Thank you.
Thank you very, very much. And I'm sure you're getting a very resounding round of applause from all the participants in this webinar. Thank you very much. That was very comprehensive. And I know we had to cut you short, but it was deliberate that you had to handle this topic because, as you alluded to, your firm and you yourself have great experience in dealing with these issues. Your topic is very important because it's the one that many lawyers come in touch with, you know, the litigation aspect, the claims aspect, the damages aspect for passengers, cargo, for delay. Fortunately, since the safety record of Nigeria has improved over the last few years, we haven't had the sort of sad cases we had when there was a spate of aircraft, fatal aircraft accidents. So what you've touched upon is very, very important. And I'm sure during the question time, many of the issues you alluded to will be treated in greater depth. Thank you very much. We appreciate your presentation. The next speaker, who's going to now talk about a totally different aspect of it, but of course very related, is Mr. Modi. He's going to talk about the Cape Town Convention and basically how it applies in Nigeria and what it does in terms of acquisition of aircraft. Mr. Modi heads the maritime and shipping practice of Lucrative body. He advises on all aspects of maritime, shipping, and admiralty law. He also heads the firm's aviation and intellectual property litigation practices. Mr. Modi is a seasoned litigator who has extensive experience in litigation matters concerning aviation law. He currently acts as lead counsel responsible for handling all litigation matters instituted against an international aviation industry giant in Nigeria. He led a team that successfully obtained a judgment of over $9 million for a helicopter services provider, being the total outstanding and unpaid sum due and retained by a local Nigerian airline under several agreements. He's been involved in several aircraft recovery proceedings in court and has advised leaseholders and financiers with aircraft recoveries issues under the Cape Town Convention. He currently acts on behalf of international airlines in passenger and baggage claims. His areas of specialization include commercial litigation and arbitration, maritime and shipping, oil and gas, admiralty, construction, aviation, franchising, debt recovery, as well as general civil litigation matters, both at the trial and appellate levels. He advises on all aspects of the Nigerian litigation practice and procedure. His expertise is well recognized in the public domain, and it includes publications such as Who's Who in Nigeria Legal 2012, where he was described as a legal practitioner with an astute legal mind. The Intellectual Marketplace Analysis 2013 describes him as an excellent negotiator and a formidable litigator. Mark has a sound understanding of aviation, maritime, and shipping practice. His very pragmatic approach to dispute resolution and strategy, as well as resolute commitment to the best interests of his clients in transactions, and the inevitable attendant success makes him an invaluable member of the team. He is a thorough professional. Mr. Modi is a member of the Nigerian Bar Association, the International Bar Association, and he's a fellow of the Chartered Institute of Arbitrators, UK, and is certified mediator of the Chartered Institute of Arbitrators. His memberships include fellow of the Chartered Institutes of Arbitrators, certified mediator, Chartered Institute of Arbitrators, member Chartered Institute of Arbitrators Nigeria branch, member Nigerian Bar Association, member Nigerian Bar Association section on business law, member of the Anti-Counterfeiting Committee of the International Trademarks Association. He was called to the bar in 1989, and he graduated from the University of Benin and has spent most of his legal career at the very leading law firm of Aluko and Oyebode I think before I ask him to start, I would like to repeat a very important paragraph in his profile, which is what I was actually trying to commend at the beginning of this program. And that is, not only does he have a sound understanding of the technical aspects, he has a pragmatic approach to dispute resolution and strategy, as well as a resolute commitment to the best interest of his clients in transactions. And the inevitable attendant success makes him an invaluable member of the team. And that really is at the core, at the heart of building a successful litigation, whether it's arbitration or aviation or anything else, a successful law practice. You must always have an appreciation of your client's interest at heart. And as Chinasa said in the course of her presentation, we see a lot of claims that really should not have been brought in aviation. We see a lot of claims that if the lawyers actually knew what they were doing, they wouldn't bring them. They'll tell the clients that, sorry, you can't get more than $1,000. You can't get more than $5,000. But you sue for $10 billion. And 10 years later, you don't even get the $1,000. And I think that's a point that all of us have to bear in mind. I'll use this opportunity before inviting Mr. Modi to welcome all the new, or the people who were not with us, participants who were not with us at the beginning, especially my learned friends in the Silk and all the other members of the bar. You are all very welcome. Mr. Modi, the floor is yours.
Leonard Silk, much obliged for your very kind words. I'm really grateful. I'm grateful and touched by your kind remarks. Thank you so much, sir. Madam Chair of Unity Branch, I greet Ma and all the Leonard Silks and my esteemed Leonard friends on the call. I greet all of you. All protocols I hope have been observed. Thank you very much. I want to thank Leonard Silk, Mr. Babalola, my dear sister Ogechi Abu, and the Madam Chair of the Unity Branch for giving me this opportunity to share what little I've been opportune to come across in the course of practice with this esteemed gathering this afternoon. So I'm grateful for the opportunity, and let me kick off by saying that where do I start now? There is let me start by talking about the Cape Town Convention and maybe the salient point within it would then come bubble to the surface. So the Cape Town Convention was adopted in 2001, 16th November 2001. It has three protocols: the aircraft protocol, which is the one that we're interested in today, the rail protocol, and the space protocol. And it was created to provide a global and uniform solution for the protection of rights and interests in high-value assets, such as aircraft. So the Cape Town Convention has been domesticated into Nigerian law as a schedule to the Civil Aviation Act 2006 under a certain declaration that was made in, I believe, it was made sometime in 2007. So the critical point I wanted to make is that, prior to the Cape Town Convention, there was a lack of uniformity and certainty with regards to lenders. I mean, as we all know, the aviation industry is a capital-intensive industry, very capital-intensive industry. And what you find is that in markets where, for example, you have, let me give an example, for example, United Airlines, I think it's the fourth largest airline in the world in terms of aircrafts. It has over 800 aircraft. 800 aircraft has been in existence for over 100 years. The point I'm making is this, that the cost of a 737 is over $100 million at this point in time. And for anyone to acquire that major asset, it requires significant financing. And no financier is going to give you that kind of money if he does not have security for his assets. So the point being, and particularly for those of us who are, looking to make the aviation industry a lucrative, or looking to see how lucrative it can be, we need to understand the business aspects of what we've been talking about, or of the industry. So, for example, the erudite comments that Chinasa has made with regards to the bread and butter issues, that's the cargo claims, the injury claims, the delay claims, all those types of things. That's one aspect of it. But the Cape Town Convention is another aspect that legal practitioners can look at and say, okay, how can I, plug in and make the most of it? Mr. Zino is going to talk about the financing, because in truth, in my view, I would have thought the financing would come before this, but I defer to the organizers. But before a person chooses to finance the purchase of an aircraft, he must be certain that, look, I'm going to be able to get my funds at the back end. One of the things that has plagued the aviation industry in this country is the lack of financing. And part of the reason why, why the industry is the way it is because there's not enough money going in. So for lenders, it is things like the Cape Town Convention, and even institutional investors in Nigeria and the banks and so on and so forth. This convention is what would provide security that at the end of the day, when I put my money in this high value asset, I'll be able to get it out. So I just thought to mention. That I'm not going to. I'm going to speak through my talking points. I may not refer to the slides per se. I think it's. I prefer to be a bit more fluid, but the slides are available for anybody who wants to get hold of them. So some of the main provisions of the Cape Town Convention is that it creates what is called international interests. It creates international interests. Now, for the convention to apply, the debtor usually must be in a contracting state. That is to say, a country that has taken on board or domesticated the Cape Town Convention as part of its domestic laws. The reason being that the existence of the legislation within that country gives the lender or the provider of the money for the purchase of the assets the security that I can go in and get my property, assuming there's a default. Because of this international interests that were created, an international registry situated in Dublin, Ireland, was created to allow the registration of interest and to allow the registration of priorities regarding aircraft. So the way the thing works is this, that if you have an interest in an aircraft, in fact, the ideal scenario is, first of all, you go and check that the aircraft, using the aircraft serial number and its registration number, is in fact has no other priorities. Pretty much the same way you do a search or due diligence at the lands registry. Then when it's clean, then you can then go ahead and register your interest. Now, assuming there are two interests registered regarding the particular aircraft, what would transpire is the first in time will take preeminence. And if an interest is unregistered, then it cannot even compete at all with a registered interest. So those are some of the aspects of the Cape Town Convention. Another aspect that is necessary to mention, and this is with particular reference to Nigeria, because of the declaration that was done in 2007, when a lessor, when someone leases an aircraft, for example, or hands over an aircraft on the basis of the security, there is a process called irrevocable deregistration and export authorization. It's called IDERA. And you do this with the NCAA. So the NCAA, whenever the lender or the one who has advanced money takes a position that, look, my security of the money, my investment is in jeopardy, guess what? I want to pull my aircraft out of this country. Because he has filled the IDERA beforehand, and in fact, all the documents are signed up front or undated. He simply files the branding process indicating that I want to pull my aircraft out of the Nigerian airspace. and the NCAA is duty bound within a space of 7 days to ensure that that aircraft is exported out of Nigeria. I mean, I must confess that a bit like Mr. Leonard Silk, Mr. Fubara, I stumbled on the IDERA by mistake. An entity in the an American company that leased an aircraft to an airline in Nigeria had asked us to recover their aircraft. So we had gone to court under the Admiralty Jurisdiction Act, obtained an order of arrest and all the subsidiary and ancillary orders we required in order to take possession of the aircraft. And then a return date was set. So in the process of intersecting with the regulatory authorities at the airport, the NCAA called us in and said, look, the truth of the matter is that because of this particular convention and this declaration, we would prefer, it does Nigeria service if this order of arrest is not in fact implemented, is not enforced. So they came to court, they spoke openly with integrity and said, look, my lord, we don't need to enforce this order. We give you a guarantee that before next Friday, this aircraft will be released. And as true to their word, this aircraft was released just as they said. And it was that stepped us on inquiry. And ever since then, I think we've done like 2 or 3 more after that. So that's what it does. It not only covers the physical aircraft, it covers things like the APU, that's the alternative power units, those things that make the aircraft run, while the engines are off, engines, engine parts, etc., landing gear, all those things are covered by the covered by the act. Please, the person on the slides, could you help me out? There's someone I'm talking about the Midwest case. Please, could you pull up to me, please? 1 second, please. Yes, thank you so much. You are there. Now, the convention and the protocol were tested in the Air Midwest Nigeria case for the deregistration and repossession and export of its aircraft from Nigeria. Air Midwest was a Nigerian operator who contracted the lease of a Boeing 737-500 from Celestial Aviation Trading 21 Limited, a company registered in Ireland. Since the lease had defaulted, and the lessee had defaulted, and the lessor sought to deregister and repossess aircraft by lodging a duly executed IDERA with the NCAA. After being notified of the termination of the lease and request for deregistration, the NCAA only deregistered the aircraft 2 months after the request was served on it, which was contrary to Article 10, Subrule 6 of the protocol, mandating the deregistration and repossession and export of aircraft objects within 5 working days. As a result of the delay, the lessor commenced the action for the repossession of the aircraft in the Queen's Bench Division of the High Court in London. In return, the lessee instituted a counter action in the Federal High Court of Nigeria, contrary to the forum of choice stated in the agreement. Although the convention provides interim preservation for a lessor, the lessee filed an ex parte application at the Federal High Court and was granted orders for the arrest and detention of the aircraft. The lessor, in turn, filed a preliminary objection challenging the jurisdiction of the Federal High Court and a motion for discharge of the warrants of arrest, repossession, and export of aircraft, pending the hearing on jurisdiction. Subsequently, the court granted the order discharging the warrant of arrest and repossession of the aircraft for want of jurisdiction. So notwithstanding the order of repossession, the lessee, through its directors, continuously prevented the lessor from exercising its right to repossess and export the aircraft. So the upshot of all of this is this. When Nigeria, in my view, fails to adhere to its convention obligations, what it does is that it puts us on a blacklist, meaning that potential investors in the industry in Nigeria become wary. But I'm happy that my own case, the SEL case and the Air Nigeria case, was different. Even though I had an order of arrest, ultimately I did not need to execute it, because at the end of the day, the courts, NCAA did the needful. They complied timelessly. In fact, in 5 days, the aircraft was out of Nigeria. In summary, this is what the statute does. What the convention does is seeks to protect the lenders who are sending or who are investing in high value assets in the aviation industry in Nigeria. It provides them with the protection when they provide financing. So it's something worth taking on board. Now, I want to move on to something that is not in my slides. And it deals with the question of why should aviation be an attractive port of call for legal practitioners? Now, one of the ways, in my view, to get into the industry is to create value by or through thought leadership. We need to create value by or through thought leadership. We need to write articles. We need to do the necessary research. We need to do capacity building by attending seminars, by attending offshore seminars, those kinds of things, and networking. It is that's the kind of environment that will allow you, receive the necessary referrals that will allow you plug into, the potential in the aviation industry. We must look to create value. The reality in life is that nobody just takes money and begins to look for who to throw it at. No, you have to have something that they want, and the way we show it is by developing personal capacity in the aviation industry, and then creating value through thought leadership. Maybe there's an aspect of something that was said today, particularly in Chinasa's wonderful paper about how to deal with passenger claims, delays, when is a claim outside the Montreal Convention, etc., etc. Those are the kinds of things that people want insights on, and when you consistently provide those kinds of insights, people will then ask you when an issue crops up. You know what? I need you to act for me. So that's one thing I wanted to mention that is not in my notes. The other thing that I wanted to mention, we've kind of touched on it by saying capacity building, but part of in specific terms, our capacity building must translate to familiarizing ourselves with, like, the Civil Aviation Act, the Montreal Convention, the Cape Town Convention. All these things are the building blocks that then allow you, speak, intelligently to a foreign legal counsel who is interested in knowing someone in Nigeria who has capacity in the event that he may want to do some business in Nigeria. One of my, this again is not in my notes, but it's worth mentioning. I've had to deal with there's a foreign airline that I'm currently acting for, and the bread and butter cases are cases that touch on the Montreal Convention. Did you properly deliver my bag, or where is my bag, or was there actually a case of delay, or the person traveled to another country in the course of his connecting flight, he was told that his passport or his visa was inadequate. Who's responsible for those kinds of things? Those are the kinds of things that actually, in my view, form the bread and butter of the aviation industry that we must do our best to, familiarize ourselves. Another, and this is in the slides now, in the section called opportunities, that the person handling the slides has wonderfully, put up. So some of the legal symposiums that we need to try and get into is for example, the IATA Legal Symposium. So it's the world's premier annual law aviation event. I put up what you call it, a link there. There's the International Aviation Law Conference, And then there's the International Conference on Air Transport and Operations. Now, you heard when Leonard Mr. Fubara was talking about how he got into the airline industry. He was going to the IBA. What do people go to do at the IBA? Aside from learning stuff, it's to network. It's to network, which is why it's critical that if you want to develop a practice in this broad area in the aviation space, it's critical that opportunities like this should be on the lookout. I recall there's also an IATA convention that is extremely popular. That's another, what you call it, legal gathering or gathering of people within the aviation industry that if you can, then you must go for it. Maybe to use as an analogy, you have this oil and gas, what you call it in Texas, that they hold every year. Anybody who does any work in oil and gas in this country shows up at that what you call it, at that
OTC.
OTC, thank you, sir. Anyone who's serious in the oil and gas space, they show up there. The International Trademarks Association, another one of my regular visits to the States every year, there are sometimes over 10,000 lawyers there. And it's not that you need to make friends with all, you just need one or two, and that's it. You have a drink, you drink coffee or something, you build a relationship, and anytime he has work in this country, he hits you, he calls. So these are some of the ways to tap into the industry. Like I said, like China said, I had to cover almost 4 different conventions and several pieces of legislation. I don't have to. I'm just dealing with one particular aspect. And in my view, this is the length and breadth of it. The slides are available. I'm happy to take on questions when it's time for that. Thank you very much. Thank you. Over to you, Leonard Sil.
Thank you very much, Mr. Modi, and you did very well on time. And thank you very much for the last few comments you made about opportunities and conferences that people have to attend. I'll just add that, yes, in those days, we invested a lot of money physically attending these conferences, but COVID has created a paradigm shift. Every single member of the Unity Bar can attend so many aviation-related webinars and seminars that are taking place all over the world. So without leaving your desktop, without leaving your seat, without leaving your living room, you can join that community of people who are investing their time and their effort and their knowledge in the development of aviation. Thank you very much, Mr. Modi, for a very nice and wonderful presentation. And like you say, we'll ask you 1 or 2 questions later on. I now have the pleasure of inviting Mr. Alex Izion, who is going to talk about aircraft acquisition, registration, and operations in Nigeria. Mr. Alex Izion II is a partner at Alex Izion & Co., a leading law firm in Nigeria specializing in dispute resolution and corporate commercial matters and transactions. He heads the aviation team of the firm. Mr. Alex Izion II, obviously coming from a very distinguished pedigree, is a graduate of the University of Buckingham, UK, where he obtained an LLB. He also holds an LLM from the University of London, even though he didn't mention which college he attended. And he was called to the Nigerian bar in 2010. Let's see. Yes. He obtained an MBA with a specialization in aviation management from the Geneva School of Economics and Management, the University of Geneva, Switzerland. As an aviation lawyer, he has gained extensive experience in aviation finance, air transport regulations, aircraft leases and acquisitions. Alex has advised multinational enterprises, private individuals, and government bodies undertaking investments and provided industry insights to investors of the Nigerian aviation industry and Africa at large. He has led several teams on big ticket aircraft financing for aircraft acquisitions and aircraft operating leases into Nigeria. He has taken various courses and attended various programs at top-rated aviation institutions, including University of Cranfield, UK, University of Geneva, Switzerland, and the IATA IATA, amongst others. He's on the board of several companies and non-governmental organizations in Nigeria and in the United Kingdom. He is happily married with 3 children. Before Mr. Ezinyo, you take over, again, I'll just take one phrase or one paragraph. You say, he has taken various courses and attended various programs at top-rated aviation institutions, including Cranfield, University of Geneva, and IATA. And that just buttresses the point which was made by Mr. Modi a few minutes ago. We have to build a lucrative aviation law practice, you have to invest in knowledge. And it's not something you get for free. You have to invest your time and your effort. Not just money, I'm not talking of money, but it's actually the interest, the time, and the effort. So I'd like to welcome you, sir, and open the floor for you to educate us on aircraft acquisition, registration, and operations in Nigeria. Mr. Alex Ezinyo II.
Thank you very much, Leonard Silk. I'm so honored. It's a huge privilege to be here. Thank you so much, sir. Permit me to stand on all protocols duly observed. And also, I would like to thank the chairman of the Unity Bar for this very rare privilege. I believe I'm the youngest here, and it's an opportunity like this. I actually encountered just over about 11 years ago, Mr. YSA, and delivered a paper on developing an aviation career years ago. And it was from that encounter that I built up the interest in developing myself in the aviation sector. So I want to thank everyone on the team, Sizoge Chiabu, the chair for the section on legal practice, for this privilege. Thank you so much, everyone. So just to start off, my slides are, I have just maybe about 12 pages, but at the last page, I put a link there for everyone to download a chapter I wrote on aviation finance in the Mondak guide, comparative guide. This was last year, so it's recent. And I believe it contains a lot of the areas, dealing with some of these areas. So what I have here is just a summary, but at the last page of the slide, I shared a short link and you can download the full article. So I'm just gonna go through just these 3 areas. And I'm so grateful, the co-panelists, Mrs. Chinasa and Mr. Modi, juggernauts in this field. So they've covered a very large area. But the area I'm dealing with here on the acquisition and registration covers a different part. So for us as lawyers, I think this is an area that you would find other opportunities to serve clients in the acquisition area, in giving legal opinions to foreign airlines or financiers or lessors that want to bring in aircraft into the sector. So just to take this, so I just broke it down into 3. I'm going to cover the acquisition phase, cover the registration phase, and then the operations. So for the acquisition, some of the considerations to have, just like the Leonard Silk mentioned earlier, the idea is to actually advise the clients based on what their request is. So most of the time, when you start the subject of acquisition, it'll be based on the type of aircraft you're bringing in. Can we please stay on the first page? That's on the acquisition page. So the first thing we're going to consider is the type of aircraft you're bringing in. Does it meet the regulatory standards here for you to bring it into the country? Depending on the intended use of the aircraft. So do you want to operate this aircraft commercially? So a client approaches you tomorrow and says, okay, I need you to advise me. I have this much capital or access to this, and I want to acquire a plane to start an airline. It's different from a client that says, I just want an aircraft to take my family and my kids. It's different from someone who wants to start an international airline to be covering routes to London and Dubai. So you have to consider all of these different requirements. Who is the owner of the aircraft going to be? Is it going to be the client you're dealing with directly? Do they have a tax beneficial structure they've created to have it held up in a holding company, maybe through an FPV offshore? And then is it going to be through an airline? Is it going to be owned privately? So those are the things to consider. And then another point here is it aircraft going to be purchased outrightly, or is it going to be financed? And then the financing question, who is bringing in the finance to acquire the aircraft? Are you getting it locally? Is it going to come from financiers internationally? All this will affect your registration process, will affect the operation structure you want to have, or you want to advise the client to have. So if we could go on to the next slide now, thank you. So we start with the structures for the acquisition. And as I said before, this is largely dependent on the client. So the first option you have here is the outright purchase. So this is the full acquisition for cash, maybe for clients that are liquid. You don't really have this, you heard already how much, for example, a standard bone will cost you, maybe a regional airliner will cost you, maybe an Airbus A320. Those are heavily financed, and you most likely have foreign financiers. You will involve export credit agencies to guarantee some loans if you're getting them brand new. So a lot of times you will find for outright purchase, it's mostly maybe someone buying a smaller aircraft, or a local operator who is maybe acquiring just one or two, maybe pre-owned to start their operation, or to just start up their airline. And so the idea here is, even if they're purchasing it outrightly, you will need to dig deeper to know the best structure for them. So is it advisable for them to have it acquired directly by the company here, or by the entity here, or by the operator here? Will that be beneficial for them when you think about the tax structure of it? Or would it be better for them to have to take advantage of tax structures that could help them out of Nigeria, and any country that has a double tax treaty with Nigeria, that would be beneficial for them? So there is that option. But it will also, even if it's directly acquired or it's an outright purchase, you might still have different structures applied to it. The second option here is secured lending. So this is commonly used to purchase as well business jets, a small number of large commercial aircraft by operators. And so the secured lending can be done through either the local banks. So for example, the aircraft may not even be worth so much. Maybe you want to buy an aircraft worth maybe $10 million or $20 million, and it's something your local bank here can actually fund. So there are other considerations the clients will have. And so you would come into advice on this. And there are so many layers that a lawyer can come into advice. So even from the banking side, from the finance side, you could have either a direct lending, secured lending done directly with the client here and the bank, or you could even have it done through a syndicate of banks for much larger transactions. But most of the time, the financier will specify the equity they need, and they are kind of in control. So you find that they have stronger negotiating powers when it comes to more of these secured lending structures. Unless the airline, most of the Western airlines, the ones that have built up a huge reputation, then they have more strength in negotiating. But it's not so common here. And then the benefit you have of secured lending is that for tax issues and for your financial accounting for your client. So your client is a local airline here. What you can have is, because they own the aircraft directly, they are allowed to depreciate the cost of that on their balance sheet over the years. That's more of a financial side to be a benefit for the client. The next option will be the operating leases. So the operating leases, you have different modes for this. So you could have this through a dry lease, or you could have it through a wet lease. So the dry lease structure is more of a long-term structure. And I pointed out something here, the IFRS, International Financial Reporting Standard 16, as of 1st of January last year. So I'm going to explain this. So the different structures you have for dry leases and wet leases affects your clients differently. So if you're advising an airline, the airline probably wants to be flexible. So they want maybe a dry lease. The reason why the dry lease is a flexible option is because they can change at any point. So like recently, Nigeria got involved in, signed up to be a pilot state for the carbon emission scheme that other countries are doing. So now that means that for operators here to fly into international destinations in the coming years, their aircraft has to meet certain requirements in terms of being environmentally friendly. And so for operators here, they might not be able to afford that kind of plane. This kind of structure works to have a dry lease to explore that. Now, the reason why I put the IFRS 16 here is that prior to now, you had different structures. So if I had a client that bought the aircraft outrightly, the client has a right to deduct the depreciation every year on his books, and he has the asset of the aircraft. If you have a client that does a dry lease, what you have is he has the same aircraft that client A has, but the difference here is that he doesn't have the assets. So on his books, he can't say he has the asset the other operator has. And so what that means is that he only has the expense to take off his books every time. So what IFRS brought in 16, it changed that requirement. So now every country adopting the IFRS standard will have to, when it comes to dry leases, they have to report what they call a right of use. So if someone leases a plane for the next 5 years, and someone has bought a plane, maybe by secured lending, he can show on his books that I own this plane. So I have this asset on my balance sheets. The man that has leased the plane now, because of the IFRS 16, can say, well, I don't have the plane, but on my balance sheet, I can report that I have a right of use for the next 5 months, or the next 48 months, or for the next 4 years, or for the next 5 years. So that is also counted as, in quote, maybe a kind of asset or pseudo asset for him on his book. So that's one of the benefits here. And in advising your clients, these are some of the things to consider. You have to consider updates on tax laws. So the IFRS 16, I put here the FIRS information circular that deals with the old structure of that. So this hasn't been updated, but because we adopt the IFRS standard, it's what most airlines are doing. The second option here is the wet leases, or the ACMI leases. The ACMI stands for aircraft, crew, maintenance, and insurance. So a dry lease only gives you the aircraft. So you're responsible for the maintenance. That's your client here is responsible for the maintenance, is responsible for the registration, everything on the aircraft. But wet leases are used more for short-term operations. So people that do Hajj operations or religious tours, or people that have that arrange bulk tours. What they do is they have it for a short period of time. So most of the time, the registration stays with the lessor, the person leasing the plane to you. He's in control of the crew. He's in control of the maintenance. He's in control of the insurance. So he's not afraid of bringing the aircraft to you or to your client. So what that is that's what, but it's more expensive for clients that use that domestically. So what Mr. Modi was talking about, the fear of foreign lessors or foreign financiers, is when it comes to things like the dry leases or the finance leases, which is the third option I'm looking at here. The finance leases, also long-term, where the lessee bears the obligation of ownership until he pays off for the aircraft. Sorry, there's a typo there, lessee. He bears the ownership of the aircraft until he pays it off. And this comes in different structures. So it's common for them to have an SPV, and most of the things you will have, and I'm going to go over some of the things you will have when you go into these structures. So the foreign financier, he's giving his money. He acquires this plane, or is giving you the fund, or giving your client the fund to acquire this plane offshore. So his concern is, if you fail to meet up your payment obligations on this lease or on this agreement, how do I get my aircraft out of Nigeria? And as easy as Mr. Modi has made it sound with how easy it is to export the plane with the help of the NCA, what's actually true is that the NCA are actually very helpful. And they don't like the blacklisting. So they do everything possible to actually help. And I'm going to go into some of that when you get to registration. So there's some mandatory steps where the aircraft is owned by a foreign operator, as different from when it's owned by a local operator or owner. So for the finance leases, you could have a structure where it's a combination of the operating leases. So you will have an aircraft worth, let's say an aircraft is worth $50 million. So he's to pay off monthly for a number of years, the first $40 million, and the $10 million can be paid, or he has the option to pay that at the end of that period of the lease, of the operating lease. So that's more of an operating lease with the option to purchase at the end. You also have the hire purchase structure, where he could pay a bulk deposit down for the aircraft, which is his equity, and spread the rest off through a number of months, maybe through a number of years, until he pays it off fully and then owns it. So all of these, and this is what I'm saying, is largely dependent on the client, because if it is being financed from offshore, then you will have issues. One, the registration of the plane. Most of the financiers offshore are not comfortable registering their planes in Nigeria. So and you have different registration marks on these planes, they tie them to the jurisdiction. So if a financier based in Ireland was to offer his plane and he asks you for a 30% deposit, so your client has to pay 30% deposit, that is not enough for him to give the client the right to register in Nigeria. And most of the time, you find that you have less negotiating powers here, or the client has less negotiating powers where he does not have as much equity in the aircraft. So the issue will be whether you can register it in Nigeria. If they will let you register it in Nigeria, you might have other documentation for extra security. And that's always the issue, security. What gives the lessor or the financier that comfort that if anything happens, I can get my plane out of the country. So those are the areas you need to advise your clients on whether they're scaling the operation or whatever approach they're taking. So the next point I deal with here is other common issues you will face when dealing with these structures. So depending on the agreed structure, it's common for the lawyers to be involved in certain things. So the drafting, and most of these you will have, maybe you start with a letter of intent. So it's more of a summary of the terms. If the aircraft is, if you're purchasing outrightly, there will be maybe a deposit you'll pay into an escrow account. It gives your client the opportunity to go and inspect the plane, so your client can get experts to go and check the plane. And then here you specify the aircraft documentation you need. There is a long list to go through, but this is just a summary for you to understand. And then after inspecting the plane, you give the conditions for the delivery of the aircraft. This is for an acquisition, outright acquisition. If it's a lease, it's the same thing. You have some of these conditions, but they change. So you will have extra obligations, extra representation and warranties that your client will probably have to take up as a lessee. And then if you're a counsel for the lessor, you want to impose them to give your lessor that, or your client that comfort. So things like the insurance of the plane, where he can operate, things like if it's an operating lease where the aircraft has to return to the lessor, you will put things like the redelivery conditions. So all of these things are there. The second point is jurisdictional questionnaire. So this normally comes in as well. You have lessors offshore. Can we please stay on that? Stay on slide 4. Please stay on the slide so that people can see it clearly. So this jurisdictional questionnaire is important where the lessor, maybe have to register their aircraft in Nigeria, or they're dealing with a lessee in Nigeria. So what happens here is you will probably get a call from them and they give you a long list of this jurisdictional questionnaire and they want you to answer everything. So you have to give them, so the moment they know the aircraft is going to operate in Nigeria, for example, you will need to answer everything regarding the client, the aircraft, the laws as they are applicable to the aircraft, the registration issues, the tax issues, all of that in that list. And most of the time, the jurisdictional questionnaire transits into your legal opinion. And this covers, the legal opinion is more specific for the transaction you are dealing with. So, the jurisdictional questionnaire might have more general questions, but this one deals with a lot of things. I put some of them there: the status of the lessee, if you're dealing for the lessor from offshore, government approvals, Then even the Cape Town domestication, which is what Mr. Modi was dealing with, here they are very concerned. So it's always a top issue. And yes, we've domesticated it. Yes, it's supposed to be easy for you to export your plane as a lessor, but you don't always have that happen. We've heard from what Mr. Modi said about how some clients would still try to circumvent to approach the courts to get an order to arrest the aircraft from departing. So, but even if that's done, you still find over time, the NCA and everything, you will still have the aircraft leave where there is a default eventually. So some of, for the next point, I just put some of the headings you will have in operating leases that deals with the pre-delivery and post-delivery conditions. So things like regular, so if you go to the next slide, please, slide 5, just so we can see it. I'm not gonna go into, because of the time, you can read it, some of these things in the link I posted at the end of the slide. But there's no time to go into them in details. But this is a rundown of basic terms you will have in an agreement. So your condition precedents, the commencement of the lease, the payment obligations of the lessee, taxation issues, who bears what tax liability, an undertaking that the lessee will enjoy quiet enjoyment, will have quiet enjoyment of the aircraft during the period of the lease. The lessee will make certain covenants. What happens where there is a total loss of the aircraft. So most of the time you will find that the financier or the lessor will have extra obligations for insurance, so that where the aircraft is, so the underwriters also have to cover the lessors in the insurance certificate, things like that. And then where there are manufacturer warranties, what happens over the period of time where that is applicable, or where how that applies for the lessee who's operating the aircraft locally. Indemnities, condition of return of the aircraft. So these are all, and the rest are boilerplate templates you will have on agreements like this, but it's just a rundown of what you will have in this type of agreement. But principally what you will have, all of this will be dependent on the type of aircraft you're getting, the age of the aircraft, the residual value of the aircraft, the condition upon the delivery, all of this will affect this. So that covers the first aspect of the acquisition. I'm going to move on quickly to the registration aspect because of time. So for the registration, which is the next slide, slide 6, the main things you're going to be considering is more of the Civil Aviation Act, the Nigerian Civil Aviation Regulations. That was the point of reference so many times through this, because that's almost like, that's like the Bible of, sorry, can we go to the first, that slide 6, the one that shows the registration, first slide on registration. So normally what you will have for registration, thank you. Normally what you will have for registration is there are also things called the NCA advisory circulars. So they give requirements for you to meet the conditions set in the Nigerian Civil Aviation Regulations and even the Civil Aviation Act. So these are things to also look out for. And then prior to importing prior to the registration of the aircraft, you need an import approval from the Minister of Aviation. So you have to apply to the Ministry of Aviation. So this is what your client will be doing here. And all of this will be based on the license, because under the Civil Aviation Act, I think sections 30, I think 34, 32, 33, 34 deals with all of this. Also section 32, so I didn't put that here, but you can see that in all the others. It deals with the fact that no one can operate an aircraft in this country without having a license to do so. And there are certain conditions for who can operate an aircraft and what they have to meet up to get those licenses. I deal with that on the operations part. But for this part of registration, after you get the import permits, it depends on who the owner of the aircraft is. That would depend on how you're going to register the aircraft. So if we go to the next slide now, you will see there are conditions set in the Civil Aviation Regulation. So there are legal requirements and technical requirements. So if you're going to operate the aircraft for commercial purposes, it cannot be more than 22 years old. And you see that in part 4 of the Civil Aviation Regulations. And it must not be registered in another state. That's common. And then, so that's a basic requirement for the aircraft to come in. So this is, I'm on slide 7, please. You can go to slide 7. But what is more important is the condition of who can own an aircraft. And that's what the concern of the NCAA is in Nigeria. So I know we know about the NIPC Act, the Nigeria Investment Promotion Commissions Act, that allows for anyone to start a company here. Yes, you can incorporate a company here, you can start a business here, but if the majority shareholding of that company is not by Nigerians, you will not be given a license to operate an airline or anything to do with aviation. It is very sensitive. You see this in Section 33 of the Civil Aviation Act. It's specific. So, and then Section 34 deals with mandatory safety standards that you have to operate. So all of this, and that's why you see these conditions. It must be a Nigerian citizen, an individual citizen of another state who is lawfully admitted for a permanent residence in Nigeria, or a corporation here, which is an entity here, or a government entity in Nigeria, or where the aircraft has been leased into Nigeria. So that's a condition. Now, you then come to, so when you come to the next slide, the technical requirements, then you see what has to be filled in. So the technical requirements is, I'm not going to go into the technicality of this, but normally what happens is where you've dealt with the acquisition phase. In the contract you will have in the acquisition phase, there's going to be a part dealing with what you call a deregistration of the aircraft. So aircraft carry marks, national marks. Nigeria has 5N, 5 November. The US has November. Now, so when you see the mark on the aircraft, where the aircraft is going to be exported from a certain country to come into Nigeria, that's what this means. The first requirement here, a notice of deregistration. That is sent from the states. It's done between state and state. So the Civil Aviation Authority of that state issues that and sends it to Nigeria, that this aircraft is going to be taken off our records, our registry in the US, and it's going to be registered in Nigeria. So if it's a brand new aircraft, then there's going to be a notice from the state of manufacturer to state that the aircraft has never been registered before. So all of this has to be done for the aircraft to be, so the NCAA has to have this, as well as other documentation you will see here. So you also have to include a certified copy of the insurance certificate of the aircraft, the license you have, and I'm going to deal with the licensing on the next section. This is either an ATL, air transport license, an AOP, an air operating permit, or a PNCF, a permit for non-commercial flights, or a permit for aerial aviation services for those who are doing flight schools. Now, so these licenses, you must have one of this to import the aircraft. So you have to have that, a copy of that to submit to the NCAA. Then your client has to have, pay the prescribed fees, and then a copy of certificate of incorporation if it's a company that owns the aircraft, or your government ID card if it's an individual owning the aircraft or acquiring the aircraft. And then the permit to import, which I mentioned before, that the Ministry of Aviation will issue. So when you go down to the next slide, which shows the legal requirements, then you will see this is where you now see what has to be provided. So one, you need to show that you own the aircraft or have control over the aircraft. So normally the purchase agreement you have has to be filed with the NCAA. Can we please stay on the slide? Stay on page 9. Can we please stay on page 9? Can we please stay on slide 9? I think the slide is going faster than my presentation. Thank you. So the legal requirements here. So the bill of sale is also what is signed to transfer title from the old owner to the new owner, which is also filed here at the NCAA. Normally, you have to have stamp duties paid on any of the documents you're registering. And then I've shown you the details here. Now, you also have a copy of a lease agreement. So what you find now is that if the owner, so this is what the point I was trying to make from before. If the owner is a Nigerian, you don't need a lot of this. The next portion you see here. The certified copy of what you call a deregistration and export power of attorney. The NCAA forces you to file this when registering an aircraft if the owner of the aircraft is a foreigner. So if an operator leased the aircraft from a different, an offshore entity, or an owner created a structure where the aircraft is owned by his holding company offshore, you may have this. So you will need to file 3 things here you need to file whenever you register an aircraft for your client. The registration and export power of attorney, they force you to do that. You sign an indemnity letter to indemnify the NCAA if you're not supposed to have registered that aircraft, or if there's any legal actions arising out of the registration of that aircraft. And what Mr. Modi dealt with, the IDERA, which is the irrevocable deregistration and export request authorization. And what this does is that anyone that has the IDERA can actually approach the NCAA without going to the court, actually. Approach the NCAA, use self-help to get the aircraft out. That's what the convention, the Cape Town Convention, is actually supposed to allow. And that's why it was there, to safeguard the export or repossession of the aircraft where this comes. So the difference here is that where you have a local owner who's a citizen of Nigeria owning the aircraft directly, you would not need to file this. Where it's a foreign owner or a financier, you will need to file the IDERA, the registration and export power of attorney, and the indemnity letter. And then you also need to have a letter stating who is responsible for filing anything or liaising with the NCA in regard to that aircraft. So the effect of registration, finally on the registration part, is next slide, slide 10. Thank you. Is that once the aircraft is registered, a certificate of registration, a C of R, will be issued. And before your client can operate it locally, it needs a certificate of airworthiness. And the regulations deal with that. You can see all of that there. Then I've just put there for you to look at later what happens when an aircraft is deregistered. So if you're selling the aircraft eventually, how to deregister it here, or conditions under which an aircraft will be deregistered. So you can see there where a lease has expired, where there's been destroyed or lost. It's just for reference for you to see that. And so now on to the last part of my presentation. It's on the operations. And to actually go into operations of aircraft locally, as I said before, you need a license. And this is slide 11, please. You need a license. I didn't want to go into so much detail on the last slide, slide 11. You will find them in the articles set out because it's actually quite heavy. So depending on the license, so I'm just going to run through it. Before your client can operate an aircraft locally, he has to have one of these licenses. I forgot to put the PAS, which is the permit for aerial aviation services here after the PNCF. So the first license you have here is the ATL, which is the air transport license. It's the largest license you have. It allows you to do scheduled operations. So all the airlines you see doing now, this is what they have, most of what they have for scheduled operations. You can also do charter operations with it. And to do this, you also have to advise your clients on the minimum share capital you need for the company. So if you want to do domestic operations, 500 million, for regional, 1 billion. And then for intercontinental, 2 billion. Then for the AOP, this is for non-scheduled operations for those who deal with business jets, but on a commercial basis. So excuse me. Oh, dry. So for the third license I put here, which is the ATO, this is not for operating aircraft. It's for those who operate tours, travel tours, and holiday schemes. So they can bring an aircraft with this license. Just to mention, before your client gets any of these licenses, especially the ATL, the AOP, the PNCF, and the PAS, they need to go through security clearance. So most of the time, your client will need to go through DSS to be cleared before a license can be issued. The ATL is issued for 5 years. AOP and the PNCF issued for 3 years, as well as the PAS. They issued for 3 years, and the ATO is 2 years. So these are just some of the rundown. Then the last point I'm going to cover is the AOC. The Air Operator Certificate is a safety standard, a technical requirement for those who are operating commercially. So for those who are going to get fares or revenue for chartering, and this applies to those who have the ATL and the AOP. It doesn't apply to those who have the PNCF, which is the permit for non-commercial flight operations. They have a different standard, or the PAS, the permit for aerial aviation services. So the AOC is a safety standard. And when you get these licenses, the client will be given the conditions which they have to meet up to commence their operations. And one of the main conditions you will see there is that for the ATL and the AOP, they have to acquire their AOC before they commence operations. So this is just a rundown of all of these areas: the registration aspects, the acquisition aspect, the operations aspect, for us to get an idea. And that's the link I mentioned at the last page. So you can search that link. It'll take you straight to the page where this article is, and then you can download it, and it's a much larger guide for you on this area. And I just want to encourage anyone. It's a huge privilege. I want to thank the chairman. I want to thank the whole team, the Learned Silk here present, for this opportunity. It's a huge privilege to be here in such a short time, to be doing this and to even have learned this much, even from the others. Aviation is so wide, so interesting, and you keep learning every day. You can never get the whole of it, and it's such a privilege to do this. So thank you very much, sir. I'll be available to take any questions when it's time for the questions.
Thank you very, 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 very much. And I'm sure you can, if you go to participants, you'll see them clapping. That was a very, very, very masterful presentation. Before we go to questions and answers, please, can they just put up slide 6 of his presentation? Slide 6, page 6, I believe it is. Could you put it up? Aha, you see that aircraft, 5 November IZY. That shows you how lucrative aviation law practice can be. That is ISIO registered aircraft, 5 November IZY. We shall now have we shall now go to questions and answers. I'm not sure we can take all of them. I thank all the participants who are still here. Over 118 people are still participating in this particular webinar after 2 hours. Thank you very much. There are quite a number of questions. I'll just take a few. There's one here, and I believe it will be addressed to Chinasa. Please, what are the remedies? It's from Jibrin Samuel Okutekwa, Senior Advocate of Nigeria, my learned friend in the silk. Good afternoon. Thank you for this question. Now, please, what are the remedies available to passengers whose flights are canceled, downgraded from business class to economy, or the flights are delayed? In Nigeria, you notice daily flight delays, cancellations, and such other wrongs without notice to the passengers. That's for Chinasa. I would rather actually like to take, okay, well, Chinasa, if you can hear, could you answer that? But I'd rather like to take 1 or 2 or 3 questions for each presenter so that they can go through all of them at once. There was a question on the exclusivity of actions, of causes of action, Article 29. And that's an area that causes a bit of confusion, as you rightly pointed out. Can you only sue in aviation under the convention, the Montreal Convention, or can you bring any claim according to your domestic law, but the remedies would only be limited by the convention? That's a question that has been raised in different ways. So please, Chinasa, could you take the Leonard Silk's question and the second one on Article 29?
Thank you, Leonard Essien, and thank you also, Leonard Essien, for the question. You noticed that I had mentioned the NCAA regulations relating to consumer protection, right? The thing is that what the convention deals with, from all the ones you raise, delay is the only thing the convention deals with. So in terms of cancellation, denied boarding, downgrading, upgrading, the NCAA regulation deals with that. And it provides, for instance, you can be paid back your ticket, gives you comfort, transportation, and all that. But the convention doesn't deal with compensation in relation to cancellation, denied boarding, or or delay. You can bring a claim for breach of contract maybe, but that is not a convention claim. And you don't have, there are no, for instance, set out terms that you can rely on. And if you are setting breach of contract, you also remember that the airline will be open to make claims. Okay, I'm not in breach because there are certain terms stated in your contract. For instance, if there are security issues and the aircraft cannot fly, it will be stated clearly in your contract that if there are security issues, your flight may be cancelled or delayed. So, but the NCAA has made, robust provisions in the MCAS. Unfortunately, many passengers don't bother to, enforce those regulations. The airlines don't also, do what they are supposed to do in terms of the provisions that the regulations have made. So we are caught where we are essentially in terms of cancellation, deny boarding. But delay, clearly, if you are delayed, clearly it's a convention claim and you can sue the airline under the terms of the convention. The second question relates to exclusivity. Like I mentioned, it's a constant issue, right? Whether the convention provides the exclusive remedy for damages occurring for death and all the other terms under the convention. It's still an ongoing debate. So you will find people saying that no, it doesn't. There are many cases actually, and because of the objectives again on both the Warsaw and Montreal to establish a uniform kind of rules for airlines, because airlines want certainty. They don't want to be open to liabilities that are crazy. If there are some jurisdictions that can give damages of millions and millions of dollars. So because of that underlying basis of certainty for the airlines, it's more for the airlines. Courts are reluctant to, just say you can bring any claim, and they say, they hold that the convention provides the exclusive remedy for issues governed by the convention.
Thank you very much, Chinasa. I was going to add one more question, which relates to breaking of liability limits, because that's where another issue that is very, very topical. And it appears that in the recent past, in the last year or two, Nigerian courts have taken a very liberal view of what is willful misconduct. Starting from the Atoebi case, which, well, people have their views on that case. But the point is that now you have the recent Emirates case, and you have a recent KLM case, where in one breath, the court will say, we understand and recognize the Montreal Convention as being applicable. And then without any evidence at all, they now say, however, there was willful misconduct, and then proceed to give huge damages. What is your view on this trend, please?
I think, that's why this kind of forum is very good. I think lawyers should actually understand the nature of the claims clearly when they are filed and know how to, present it to the courts. And I think, you've mentioned here that there have been, when they read out your CV, there are many forums where judges have been, they've tried to, let them know essentially what the convention provides and how they can be applied. For instance, that Mekuye and the Emirates case, for me, it was like a denied boarding case. It's difficult to understand the basis of saying, okay, the convention applies, and then you're now talking of breaking liability. The history of willful misconduct that allows you to break the liability up to even now, where the Montreal doesn't have that language, but still you see that the cases will use the basis for defining willful misconduct to determine those cases. There were strict kind of rules interpreting willful misconduct had to be clear. In the Haka Air Services case, it was quite clear that, look, the factors that led to that accident were, you could agree that yes, there were some terms of will. There were the pilot taking off at that kind of weather and providing it. But other cases are not so clear cut. That will run the risk of having a body of decisions that are not clear, and people can rely on them to push certain principles. So
I think this is a good point to stop you there, because I don't want to get started on this, and we are running short of time. But the point you make is very important. Once there is no predictability in aviation, your jurisdiction will be blacklisted, and that's why it's so expensive getting aircraft into Nigeria, because of this lack of predictability and the fact that foreigners who own the aircraft or financiers do not understand our jurisdiction, because there's no body of laws that is consistent that they can say, this is what's going to happen in this particular case. And talking about consistency, Mr. Modi, Mr. Modi, I hope you are still on the line. I'm sure you are. I was just going to ask you, in your presentation, you talked about bringing an action under the Admiralty Jurisdiction Act. I wonder if you can explain that to our participants, how the Admiralty Jurisdiction Act is applicable to aviation matters. Mr. Modi.
Yes, I'm here now. Yeah, under Section 1 and Section 2 of the Admiralty Jurisdiction Act, it recognizes or the jurisdiction of the Federal High Court is extended to cover both maritime vessels and aviation assets or aircraft. So that's the basis. That was the springboard of the action that I took at the time, because it allowed it. Having said that, because of the Cape Town Convention, it's effectively rendered the aviation aspects of Section 2 and the arrest procedure. It's rendered it redundant, if you like. So but that's the legal basis premised upon which I did what I did there.
Thank you very much. I see that Leonard Silk Etigwe has raised his hand, but I don't see if he has posted a comment or if he has a question. Please, the person controlling the chats, the questions, can you scroll down so we can see the questions? Because I can't see them I cannot move them from here. Hello?
Mr. Itiwe, while Leonard Silk has posted a comment here that there are currently no liability limits. He made a comment here, there are currently no liability limits. So I don't know, maybe he wants to throw some more light on that, or is essentially telling us that we shouldn't worry about limitations, limits with liabilities, that there are currently no liability limits.
Well, Mr. Tigwe and Chinasa have been involved, like I said, in the review of 6 of the aviation laws. Maybe he knows something that we don't know yet, but it would be good if he can, in the chat, expatiate on that. But while that is going on, permit me to ask Mr. Alexis Zion, from your experience, what would you say the biggest or the most important considerations are in terms of financing from the point of view of the foreign financier or the foreign lessor? Your microphone is muted. You are muted.
Okay, I was trying to unmute you, it wasn't letting me. Okay, thank you, sir. Okay, considerations for the financiers.
Yes, or lessors.
I just wanted to clarify your.
Yes, the question is, what from the point of view of Nigeria as a jurisdiction, because the reason I ask the question is that we keep on asking, why can't we get aircraft into this country? Why can't our domestic airlines bring in, have capacity? And so the question is, what is it about our own domestic situation that is giving concern to international financiers and lessors?
Yes, so many things. One of the things you mentioned, Silk, was the fact that we don't have a body of laws that gives predictability for the lessors. And mixed with that, you have other restrictions. So most of the payments for these financing you have is in US dollars. So even export control issues, how do you get operators to mop up? I think just about a week ago now, they've restricted dollar deposits or even payments in almost all banks now. So you have issues like that. So operators are dealing with this, causing delays in payment of their obligations on the terms. So you have these delays. You have even issues with condition of the redelivery of the aircraft. So that's also an issue for the lessors, the financiers. You don't have as much support locally. So most of the maintenance has to be done offshore. That is also a problem. So you want to compound this with other challenges of, I know the airlines have been complaining of multiple taxations and so on and so forth. So there are a lot of issues, but from the lessor's perspective, the idea is, will I be able to get this aircraft out? Do I have enough security on this aircraft that I'm financing? Unless they have an extra guarantee, or I've seen structures where they've had maybe like Standard Chartered Bank also to serve as the guarantors of the asset here locally. So there are different structures they will use. And most of the time where you have that, it just makes the structure a lot more expensive and cumbersome for the operators here.
Okay. And a good example is the recent case of Top Brass, where they brought contempt proceedings against the Director General personally of the NCAA because he wanted to implement the convention and the IDERA. And
on the IDERA, yes, sir.
Yes, and the regulator is now being put in that sort of position. Thank you very much for your response. I'm told that we have run out of time. I know there are quite a number of other
questions. There's one here directly to you, sir, Mr. Anga, from your learned brother, Mr. Rutimi Oguensho.
Okay.
And he says here, he says here that the Nigerian courts, when considering claims under the convention, still approach matters as if they are deciding common law claims. What can we do about this?
Well,
the attitude of the courts.
Well, I think the simple answer to that is just education, knowledge sharing, that's all. You see, the commercial aviation is just about 100 and something years old, and it emerged from military purposes. Now, the only way an airline can fly, especially internationally, is if it knows that, aviation by definition is dangerous. And by definition, anything can happen. When you give your bag or your luggage to somebody at the counter, that piece of luggage can go through 100 hands. And if it gets lost, the owner of that luggage is in no position to determine where or how the bag got lost. And if you are to deal with evidential rules of different jurisdictions, will you apply French law? Will you apply German law? Will you apply Nigerian law? And that is why you have a uniform body. And what you get as a passenger is that once you've handed over your baggage or once you've boarded an aircraft, you are going to be compensated, but your compensation will be limited. And then the airline goes and insures that risk. The minute the liability is unlimited, it means they cannot insure their risk. If they cannot insure their risk, they will stop flying. And so the question is, do you want a jurisdiction where there is no certainty or predictability in interpreting this uniform body of laws? And the simple answer to the learned silk is that it's joint and collaborative work for us to share knowledge and understand why. Of course, if you lose your luggage or if you miss your flight or if you are delayed, you feel it. But if you look at it from a purely industry point of view, there's a reason for the structure in private international law that has been created. Is there another question? Okay, Ogechi, before I call on you and the learned silk, Mr. Babalala, to give a vote of thanks, I think I'll just conclude by saying two things. One, that, especially here in Nigeria with close to 200 million people and terrible road infrastructure, there's no reason why Nigeria shouldn't be leading Africa in aviation. I mean, there's absolutely no reason why we shouldn't be and especially our geographical location as well, at the corner in the armpit of Africa. A 6-hour flight from Lagos can take you to almost anywhere, to at least 4 or 5 continents. And so what I keep on asking is, why aren't we doing it? We want safe, secure, economically viable aviation. And the only way we can have that is by having transparent laws and regulations and policies, which are appropriate, relevant, and realistic. And that is where our government comes in. Our laws should be appropriate, they should be relevant, and they must be realistic. We want a proactive and empowered regulator. The Civil Aviation Act, which I think we and myself and a few others were able to produce in 2006, separated the Ministry of Aviation from the regulator. But then you find that the regulator is always in the minister's office. And so you have a problem. The ministry is supposed to be for policy. Operational safety and security is supposed to reside in the NCAA. And we need an empowered Nigerian Civil Aviation Authority. We need modern equipment. The panelist, Mr. Ezion, talked about environmental considerations. Very soon, no aircraft from Nigeria will be able to fly to anywhere in the world because of carbon emissions. So we have to modernize our fleets. We can't be using 22-year-old aircraft. We need modern engines. And with this pandemic, it has shown that things have changed. And so to what extent is our government going to assist the airlines? And it's not a question of bailout. It's not a question of giving people cash. It is creating an environment where people can compete. It's creating a level playing field. We need more infrastructure, airports, operational air maintenance organizations, MROs, and so on. And most important, we need well-trained and motivated personnel. All these things give opportunities to lawyers to find a niche for themselves to build a lucrative and successful aviation law practice. I thank the organizers, the Abuja Unity Bar and the Section on Legal Practice for this opportunity given to all of us. And I pray that as in the coming years, we'll see more and more people practicing aviation law and making a success out of it. Thank you very much.
Thank you so much.
Thank you very much, Mr. Lawrence Fubara Anga. We are so very, very grateful. I believe you deserve a round of applause. And I'm sure a lot of people are clapping now for the job well done. Yeah, I want to thank all the participants as well. The response has been so overwhelming. We had at first over 150 people joining us. And also, we also had a lot of people who joined us later. So we are so grateful, especially for the panelists. We have Mr. Mark Modi. Thank you so much, Mr. Mark Modi. Are you still there? Chinasa, we are very, very grateful. Alex, we are very, very grateful. Now I'm going to invite the chairman of the Section on Legal Practice, Ogechi Abu, to give the vote of thanks. I mean, I've said a little. I'm going to hand it over to her.
I was saying that you had all, you had actually done the honors, but I don't know. Sometimes thank you is just not sufficient. You know, a lot of times we struggle with how to convey the depth of gratitude that we feel, but however it is, it's still thank you that we would say. So we say thank you, thank you, thank you. I would like to start with Mr. Fubara Anga, Senior Advocate of Nigeria. Thank you so much, sir, for coordinating this session and making it so interesting and eliciting the critical knowledge that we had to gain. We also thank you particularly for assuring us that there's enough space for those of us in the Unity Bar who are looking to come into the sector, you know, that it is not a saturated sector. So we thank you so much. And you have told us what we need to do, you know, the essentials, how to prepare ourselves to, you know, develop this practice this area of practice that we now need to look into. So, sir, I thank you so much. The Unity Bar thanks you very immensely. The section on Legal Practice Committee is most grateful to you, sir. Chinasa, well, from the comments in the chat box, you would see that our members thoroughly enjoyed your presentation and found it very knowledgeable, very educative, very informative, you know, very insightful, particularly for courtroom lawyers. You know, you have really opened our minds to tell us how to better present our cases, because when we go to court, we're interested in successfully prosecuting the cases, in, you know, recovering these huge damages that we want. So thank you so much for telling us about how we can break the liability limitations, you know, telling us about this willful misconduct. I bet a lot of people might not have been aware of this principle before today, but thank you so much. Thank you so much. It was a very, very, you know, potent presentation. So we thank you, and we pray that the good Lord will reward you immensely for all of this. Mr. Modi, well, Mr. Modi is my personal logger. We happen to be in the same building here in Abuja. I am in the Abuja office, and we happen to share the same building with Alukani Ebode in Abuja. So I like to think of him as my big oga as well. So I thank you so much, Mr. Modi. Thank you so much. You've really opened our eyes to the business aspect of aviation. It's not just, as you call it, you categorize it, the bread and butter. We have the bread and butter cases that we go to court for, but the real meat of it is, you know, in the business side, you know, on the business side, understanding what is required to play in that aspect of it, you know, and particularly as it comes to protecting the assets, very, very capital intensive sector, you know, and you've told us all that we need to know about how we can assist our clients when it comes to preserving their assets. So I thank you so much, sir. The Unity Bar, this section, this committee is most grateful to you. Then Alex, my Alex is like family to me, you know. So such a privilege, Alex, to listen to you today. You know, your presentation, you really opened our eyes, particularly because this is actually an aspect that a lot of lawyers can quickly break into in terms of the acquisition, the aircraft itself, you know, all of these regulatory things that you have opened our eyes to today. And so it looks doable. You know, before all of this seemed like a mystery, but you've really, really broken it down for us today. And we see that it is something that we can all do if we apply ourselves, you know. So I thank you so much. Thank you so much for your wonderful presentation today. I thank all of the panelists and moderators. Our chairperson had made the point that this session today, your presence here today did not cost us 1 penny. We don't know what we would have had to pay if we had had to hire your services, but you have graciously granted us your time, so much of your time today, you know. So we thank you so much and pray that the good Lord will continue to reward and bless you. So thank you, and thank you again. Thank you so much. Sorry, in my thanks, sorry, I'm not, sorry, 1 minute, please. I made an omission, please. I have to also now specially, please, in a very immense manner, thank Mr. Tunde Babalola, Senior Advocate of Nigeria. So at the time when our committee was constituted, this was about mid last year. At that time, Mr. Babalola had not attained the rank, the very coveted rank of Senior Advocate of Nigeria, you know. But even as that has now happened, you know, he has not changed his disposition to the committee at all. He has remained very, a staunch member of the committee, has also allowed me to continue to lead the committee, So I must thank you immensely, sir, before everybody today, for your humility, your accessibility, and your availability to us, sir. Thank you so much. This webinar today would not have happened without your personal commitment to reaching out to some of our presenters, to make this happen. So, sister, we thank you so much. The Unity Bar is grateful to you, and your committee is especially grateful to you. So I now want to thank all the participants. At some point, we had over 160 participants, and it's so gratifying to see that we had a lot of our very respected senior advocates of Nigeria attend this webinar with us, A lot of our seniors too, the elders of our Unity Bar, and our colleagues, of course. So I thank all of them immensely for finding our webinar interesting to attend. And even at this time, we still have about 88 persons still present. So I thank all of you, and I do hope that the objective of this webinar has been realized, that our eyes have been opened, our minds opened, and that all of the knowledge that we have gained today will translate into action. So much has been said. The moderator had said, aviation is a very broad section. The panelists said the same thing, but personally, I am going away feeling like I know a lot on aviation already, So even though they have claimed that it's a very broad area, but they have managed to, almost break it all down and tell us at least the rudiments, the foundation, everything that we need to know, and they've charged us to go and now do our further learning. So I thank you so much, sir. Thank you. Thank you. Thank you is not sufficient, but we thank you so much. We are most grateful. Thank you.
Yeah, that is what it takes when you stand on the shoulders of giants. Ogechi Agu, the chairman. Yes, we indeed. So just a comment. We can see a lot of emails flying about regarding the slides, notes, stuff like that. I want to assure all the participants that all the slides, notes, and all the papers will be sent to each participant. So can you just send your email to the same address, and we will ensure that you get the slides, the notes, and the papers. And I think because of the overwhelming response, I'm thinking, well, with the permission of the chairman, that we should organize a part 2. So that, I don't know what everybody says, because even though we said just 2 hours, we spent nearly 3 hours, and we have not covered anything. So I don't know what I think and we'll discuss that later. So over to you, Madam Chairman.
So thank you very much, everybody. Thank you, Leonard Silk. We will discuss it at committee level, and I'm sure that our distinguished panelists will always answer us anytime we appeal to them. I'm sure they will answer us anytime we call on them. So at this point, I think it's a safe place to close this very, very insightful, very interesting, energizing, and most educative webinar. Thank you so much, everybody. Thank you for your participation. God bless you all. Thank you.
Thank you.